at the very interesting deliberations lined up at Legal Era's 7th Annual Insolvency and Bankruptcy Summit 2022. For the keynote address, we are indeed honored to have the presence of Ravi Mittal ji, Chairperson IBBI. Ravi Mittal, sir, a former secretary at the Department of Sports, is likely to take over as the chairman of the Insolvency and Bankruptcy Board of India. Sir would work as the head of IBBI for 5 years or till 65, whichever is early. As we all know that IBBI, the prestigious body Insolvency and Bankruptcy Board of India, is a regulatory institution set up by the Ministry of Corporate Affairs for enforcing the Insolvency and Bankruptcy Code. The board regulates corporate insolvency and resolution process. It also regulates insolvency professionals and information utility. And to guide us on the way ahead for insolvency and bankruptcy matters, indeed for the keynote address, Ravi Mittal, sir, who definitely needs no introduction for the wonderful work that he has done at the national and international level, for the important expertise he has presented to corporates, to state government, to central governments. Indeed, we are delighted to have sir amongst us, and we welcome him for the summit. Ravi Mittal, sir, greetings, and we invite you for the keynote address. So, ladies and gentlemen, at Legal Era's 7th Annual Insolvency and Bankruptcy Summit 2022, for the keynote address, we invite Ravi Mittal, sir. Shri Mittal, please.
Thank you, Dr. Amna, Mr. Shroff, Mr. Vishnathan ji, other dignitaries who are present in this summit. Thank you very much for inviting me to this summit. I see that the Legal Era is organizing it. This is the 7th summit that they are organizing. And IBC itself has completed more than 6 years. So I think that you are organizing this summit on an annual basis every year, and to bring all stakeholders for discussion. So I commend you for organizing such summits on an annual basis. You know, as Mr. Vishnathan was saying, he is one of the draftsmen of the code. And sir, you don't need to defend the code because I think as a practical manager or as a practical bureaucrat, I think the code has really fulfilled the purpose for which it was set up. Now, before this code was there were multitude of legislations, and there was confusion as to how to go about it. In those times, I mean 2017-18, I used to work in the Department of Financial Services and used to look after the banks. And we were under great confusion as to how to resolve various projects. Those were the times when banks were also faced with a huge NPA problem. And this legislation has helped the banks in addressing this problem. And I will just like the magnitude of the solution that has been provided by IBC. The bank's NPA, the maximum NPA level in the banks reached about 12 lakh crores. And we all know that about 2.5 lakh crores have been resolved under this act, whether by resolution or by liquidation. Apart from 2.5 lakh crores, a large number of applications have been withdrawn, and more than 6 lakh crores cases of where dues were more than 6 lakh crores have been resolved just by withdrawal. Now, I consider cases which have been withdrawn and resolved as important, or in fact more important, than the cases which have gone through the resolution process, because this shows that the code has changed the debtor-creditor relationship. And I believe this is the most important thing that this code has done. Now, you know, we have two of the most prominent legal persons in our midst, Mr. Shroff and Mr. Vishnathan, and they are large. When I read the dignitaries who are attending, so there are large number of legal people here. So I would not talk about law today. I would like to talk about the behavior as to how do we implement the law. This is what I would like to talk today. Now, when IBC was set up, the Reserve Bank of India issued a circular which is famously called the 12th February circular, in which the RBI prescribed timelines for banks or for financial institutions to take cases into to the IBC. This circular was not approved by the Supreme Court, and another circular was issued in May or June, which also prescribed or suggested some timelines for taking NPA cases or for taking default cases under the IBC. Now, both the circulars primarily said that within 180 days of the account becoming bad or within 180 days of default, cases should go under IBC. Now, practically what is happening is that cases are going in IBC after 500-600 days. Now, if a case goes into IBC after 500-600 days, what happens is that, one, the value of the claims keeps on increasing. Because, after an account is declared an NPA, penalty starts. So the claim of financial creditors and other creditors keep on increasing. And I have seen cases where the claims are in excess of 2.5 or 3 times the principal amount. The other thing that happens is that the value of the asset keeps on going down. As time goes by, the value of the asset keeps on going down, and therefore, it is very natural that if banks or financial institutions come late into the system, the claim would have gone up, the value would have gone down, and therefore IBC or whichever system there is would result into a higher haircut. So the solution lies in changing the behavior, that is coming into IBC earlier, resolving it in a time-bound manner so that more value is realized, the value is preserved, and lower haircuts come about. In this regard, I just want to give you a figure. When a case is admitted into IBC, a valuation is done. Now, 2 kinds of valuation are done. One, a fair value is found out, that is the value of the unit as a going concern, and another, the liquidation value is found out. Now, if you look at the claim, if we look at the haircut as percentage of the claims, the haircuts are about 70% or more than 70% in the last 5-6 years. But if we look at haircut from the fair value point of view, that is the value at which the case was brought into IBC, then the haircut is less than 20%. So if we bring the case late into IBC, it is not possible for IBC to recover value which has already been lost before the case has come into IBC. So there needs to be a change in behavior of the creditors of the both financial and operational who want to come into IBC, that they should come into IBC as early as possible. This is the first point that I want to really make. The second point that I want to make is, we have this is a very beautiful law which has been written after extensive consultation. As Mr. Viswanathan said, the government has kept pace with the market, and government has made large number of amendments also in the last 6 years. IBBI has also made large number of amendments in regulations in the last 6 years. In the last year itself, we have made more than 20 amendments, and some of these amendments are big amendments. So the government and the regulator are trying to keep pace with the market. But our behavior also needs to keep pace with the market. And here I would like to state 2-3 points. The first point that I would like to state is IBC prescribes that the case will be admitted in 14 days. Now, how can a case be admitted in 14 days? It can be admitted only if we accept that this is a non-adversarial legislation. This can be done only if we accept that we only have to see whether a default has been done, whether the default has been done within the limitation period prescribed and admitted. Now, if we start looking at things, if we start, giving large number of adjournments, if we start looking at things which we did not see at the admission stage, it's possible to do this within 14 days. Now, it is here that we need a change in behavior of both the legal fraternity who represents, and also the adjudicating authority, if we have to admit this case within 14 days. I am not criticizing anyone, but if we have to implement, if we have to admit cases in 14 days, we have to change our mindset. We have to change our behavior. Now, I have seen cases where the dispute is that whether the default is 100 crores or the default is, let's say, 70 crores. Now, if IBC prescribes a limit of 1 crore, now this should be settled at the claim stage and not really at the admission stage. At the admission stage, we just need to see that what is the default, and it is very natural that the erstwhile promoter will try to bring all kinds of points before the system as to why the case need not be admitted. That is very natural, but we need to take care of it, and we need to really admit the case or bring it into the IBC system. Now, when a case is admitted into the IBC at a time limit of as 180 days or slightly more is prescribed. But what I find is that it is difficult to really adhere to that time limit. Now, what are the various reasons as to why we are not able to adhere to the time limit? There are disputes as to whether one is a financial creditor or one is a operational creditor. There are disputes about claims, whether the claim should be X rupees or claim should be X minus something rupees. There are disputes whether the resolution applicant or the person who wants to take over qualifies under Section 29A or does not qualify. There are disputes among the resolution applicant who has given as to who is a better resolution applicant. What I am only trying to say is that there are all kinds of disputes. Now, if we want to settle all, and then there are avoidance transactions, which is very clearly provided in the code. So if we try to settle all these disputes, and we have to settle these disputes, it will take time. I mean, settling all these disputes within 180 days may not be really possible. So can we devise a system? Can we devise a system where disputes which are not related to the resolution applicant, we can settle them separately, but as soon as we find that a resolution applicant is there, he has given a viable bid, that this bid is accepted by the COC. Can we approve that bid? Can we approve that bid? And can we hand over the unit or hand over the CD to the resolution applicant, so that more value is not lost, so that the resolution applicant starts operating the unit. The money that is received can be put in an escrow account, and it can be distributed as and when the court decides on the claims and other disputes, other things of the various creditors. Now, I am not saying that this is the only way forward, but can we think about such an arrangement? The other thing that I want to say is, if you go to Western countries, they have a huge pre-insolvency system. That is, before the case is admitted or before the case goes before the insolvency court or before the judicial system, they try to resolve the case either by mediation or by informal means. Is there a need in India to develop these means in a more systematic manner? That is, should we set up some guidelines? Is there a need to set up some guidelines which the creditors can use to resolve the case before it comes before the insolvency courts. Something like a pre-pack, but not really a pre-pack, something like a pre-pack. And then if it is difficult to resolve the case, then it should come to the insolvency court. Or even if we resolve the case through mediation, can that result be approved by the insolvency court? Now these are 2-3 things which I think I would request the legal brains to give us the advice as to whether it is possible to move ahead on these things in our country, or whether we should try and only improve the way we are working at present. The last point that I want to make is, there is also need to change the behavior of the creditors as to the way they behave or the way they work in the committee of creditors. They need to understand that if you take decisions fast, less value will be lost. And if you keep on fighting amongst yourself about small claims and small things, you may get a better result. But if the value has gone down, there is no pie to share. So we should try to keep the pie as large as possible, and then maybe arrive at a sharing which is not very optimal. Maybe it is not very optimal. It may be second best, but at least the pie is large enough. Pie is large enough for to be shared. As Mr. Viswanathan said, the objective of this code is not recovery, but to resolve. And the objective is that particular CD should survive as a going concern. And if it survives, it will help the economy in generating more jobs, in generating more GDP, in generating more taxes. And in the if we look at the longer period, perhaps it will help the country more than by just recovery. Now, this is another thing which creditors need to understand, and the behavior needs to be guided by this. So what I'm trying to say is, we have a law. Our law, I think, is very good. We are making amendments to the law as the market says, but it is essential to implement the law in its true spirit. I mean, implementing the law in its law is one thing, but we need to implement the law in its true spirit. We need to change our behaviors, change our way of working according to the law, according to the nuances of the law, according to the behavior of the law. And I think if we are able to change our behavior in a way that as to how to implement the law, I think we will be able to achieve far more than what we have been able to achieve so far. We just need to keep 2 things in our mind. One, we need to reduce delays as much as possible. A delay will lead to erosion of value. So whatever we do, whether in terms of law, whether in terms of regulations, whether in terms of rules, whether in terms of behavior, whether in terms of our litigation, reducing delay should be the first thing in our mind. And related to that, the second thing in our mind should be maximization of value. If we are able to give value, if we are able to conserve the value, everyone will be happy. Last thing, we should not look at haircuts based on the banks or the financial creditors' claims. We should see it on the basis of the value when the case comes before the in the IBC. If we look at that fair value, we will realize that less than 20% is lost in the process, as against 50-60% that we are really looking at. So I thank you again for inviting me to this summit, and I will try to attend this summit at least on a listening mode almost throughout the day, and get out as much as I can from this summit. I thank Mr. Shardul Shroff Thank you very much.
Thank you, sir. Thank you, Ravi Mittal, sir. Some very important insights that you presented, especially with respect to guiding all of us, all the professional, distinguished lawyers here, that reducing delay, the need to maximize value. I think some very important insights coming forward from the remarks by Ravi Mittal, sir. Thank you, sir.